Hi everyone, good morning to all. Today I am going to discuss a new part of our paper business law, that is contract of agency. So here we have to discuss what is meant by agent, what are the different types of agent, and what is the basic difference between agent and a servant, and what are the duties and rights of an agent and a principal. One by one we will discuss everything. So agent, what is that? According to section 182, agent as a person employed to do any act for another or to represent another in dealing with third person. The person for whom such act is done or who is represented is called the principal. The relationship between the agent and the principal is called as agency. So agent that defines or that is mentioned under section 182 of the Indian Contract Act. So agent means a person who is employed to represent another or a person who is employed to do anything for another. That means when one person is appointed on behalf of another person for representing or dealing with any third party, then that is called as an agent. So the person who appoints the agent is called as principal, or on whose behalf the agent is going to conduct his service or activities, that is called as principal. The person who provides the activities or who deals different types of activities, that person is known as agent. The relationship between principal and agent is known as agency. Contract of agency are based on two important principles. Whatever a person can do personally shall also be allowed to do or to be done through an agent, except in case of a contract involving personal service such as painting, marriage, singing, etc. He who does not act through a duly authorized agent does it by himself. That means the act of agent are considered the act of the principal. So there are two important principles in case of a contract of agency. Where a person is appointed on behalf of the principal, then that person is known as an agent, and when a person is not appointed, that means principal is authorized to do everything, then in that case the act of the agent are considered as the act of the principal. That means the principal is known as the agent. But when principal appoint the person for dealing with any third party or to represent another, then that person is known as agent. So now question arises, who can be an agent? Any person who is the age of majority according to the law to which he is subject and who is of sound mind may be an agent. So any person can be treated as an agent, but the condition is that the person is of sound mind. That means person is at age of majority and he is having sound knowledge to do everything. Then that person may be appointed as an agent on behalf of the principal to do all type of activities. The function of an agent to bring his principal into connectional relation with third party. So every agent who is appointed on behalf of the principal, the agent duty to conduct all the activities on behalf of the principal to make all types of relation with the third parties. The agent is merely a connecting link between principal and a third party. So simply we can say that where one agent is appointed, the agent is responsible making a relationship to or in between principal and a third party. Next we are going to discuss what is the basic difference between an agent and a servant. The first point of difference, that is scope of authority. An agent can create a contractual relationship between principal and a third party, but a servant cannot create any type of a contractual relation between employer and a third party. So this point is signifies relating to the scope of authority. Agent, there is a contractual relationship, or in case of agency the relationship is made between principal and agent. So there is a contractual relationship, but in case of a servant, where a servant is appointed, there is no such type of a relationship is made by the owner on behalf of the servant. Second, remuneration. An agent receives commission for his services. A servant is generally paid wages or salary. So this point relating to remuneration part or wages or salary part. Agent, as he is appointed on behalf of the principal, so on the basis of a service provided, agent is entitled to a certain amount of commission, but a servant is generally appointed on the basis of wages or salary. Next, on whose behalf an agent may work for several principal at the same time, but a servant can serve only one master at a time. So agent may work for anybody, maybe different types of a principal, or on behalf of different principal an agent may appoint, or he can or she can provide service on behalf of different principal, but a servant is generally appointed on behalf of a person providing the service relating to a particular person or only one person. Next point that relates to control. An agent is not subject to direct control and supervision of the principal. He is often discretion, but a servant acts under the direct control and supervision of his master and must follow all his reasonable order. So being an agent, or an agent as he is conducting his service on behalf of several principal, so in that case agent is not under direct control and supervision of a principal. His power is discretion, but in case of servant, servant is generally appointed on behalf of a master, so he must have to follow all the instruction and order made by the master, and he must take all reasonable care whenever any supervision or control is exercised by master. Next point, liability of a principal. The principal is liable for all the wrongful acts of his agent which are within the scope of his authority, but the master is bound by the wrongful act of his servant if done in the course of a servant's employment. So this is relating to liability. Being an agent is appointed on behalf of the principal, so whenever agent do any wrongful act, in that case the principal is liable for all type of claims made by the other party. But in case of a servant, as servant is appointed on behalf of the master, so when during the time of employment, when servant makes any type of wrongful acts, in that case the master is liable for that, and that is the liability of the master. Next, creation of agency. What are the different mode of creating contract of agency? One is by express authority, second by implied authority, the third one is by ratification, and by implied authority there are three. One is by estoppel, second one is by holding out, and the third one is by necessity. So we will discuss each one by one. Agency classification. The first one is express agent, that is mentioned under section 186 of the Indian Contract Act. A person may be appointed as an agent either by words of mouth or by writing. No particular form is required for appointing an agent. So express, that means that is made generally through spoken words, and there is no paper document is necessary. So when there is any relationship is created between principal and agent through spoken words or through instruction, in that case that contract of agency is created by express agreement, or that is known as express agency. The second one is implied agency, that is mentioned under section 187 of the Indian Contract Act. An agency which arises from the conduct, situation or a relationship of parties. So when relationship arises between principal and agent through on the behavior or the conduct between the both the parties, that is known as implied agency. The third one is agency by estoppel, which is mentioned under section 237 of the Indian Contract Act. When a person has by his conduct or statement induced other to believe that certain person is his agent, he is stopped from subsequently denying it. That means agency by estoppel, that means when a person has by his conduct or statement believes other that he is the agent, in that case that person is not stopped from denying any type of a service or duties made by on behalf of the principal. So there is one example. A tells B that he is C's agent. This he does in the presence of a C. So during the time of a presence of a C, A tells to B that he is the agent of a C, and within his hearing C does not object the statement of A, and as C hears that statement from A, in that case there is no question of objection, and A is not actually his agent. Later B makes a deal with A as agent of a C, and C shall bound by this deal. So during the time of a hearing, when C is not actually as an agent, but later on B makes agreement with C, in that case C is not stopped on behalf of the principal who is A. So that is known as agency by estoppel. Once a person is conduct his service as an agent but not being an agent, in the latter case he is not stopped from denying his duties. Then next one is agency by holding out, which is mentioned under section 189 of the Indian Contract Act. Though part of the law of estoppel, some affirmative conduct by the principal is necessary in creation of agency by holding out. That means when a person acts as an agent on behalf of the principal and the principal hold that person as an agent, in that case that is called as agency by holding out. That means the principal hold out that person and act as an agent or instruct that person to act as an agent on behalf of him. So that is one example. A child purchases goods from a shop and desires the shopkeeper to collect payment from his parents later. The parents, though not bound to pay, make the payment. After a few days, the child again purchases from the shop on credit of the parents. The parents would be bound this time because by making payment earlier without raising any objection, they had held their child out as their agent for making such purchase. So first time the parent makes the payment without any hesitation. So during the second time when the child makes any credit purchase, in that case the parents must have to make payment because he holds that during the earlier period and there is no question of objection that I am not able to make payment. So first he makes the payment, so during the latter time he is bound to make payment to the shopkeeper. So this is known as agency by holding out. Then agency of necessity, that is also mentioned under section 189 of the Indian Contract Act. This arises where there is no express or implied appointment of a person as an agent for another, but he is forced to act on behalf of a particular person. So that means agency of a necessity, where there is a necessity of being appointed as an agent, in that case the principal must appoint a person as agent, and that is known as agency by necessity. The question of a necessity where there is, the principal must appoint an agent. So there is also another example relating to agency of necessity. A horse was sent by rail at the destination, it was not taken delivery by the owner. So when horse was delivered or when horse was sent through rail to a particular destination, the owner is not arrived to the particular delivery station. The station master had to feed the horse. So when owner of the horse is not arrived, in that case the station master must have to feed the horse, and hence the station master become the agency of a necessity and the owner must compensate him. So when the particular person or the owner arrives at the station, in that case the owner must have to make all type of reimbursement to the station master for feeding the horse. Next is agency by ratification, that is mentioned under section 197 of the Indian Contract Act, where an agent does an act for his principal but without knowledge or authority, or where he exceeds the authority, the principal is not held bound by the transaction. That means once an agent is appointed and he conducts any type of a service and that is without knowledge or authority, or where the agent exceeds the authority, given authority, in that case, latter case, the principal is not held liable for that. So there is one example. L made an offer to X, which is the MD of company. X accepted the offer, though he had no authority to do so. L subsequently withdrew that offer, but the company ratified X acceptance, and later on it was held that L was bound. The ratification related back to the time X accepted the offer, hence rendering the revocation of the offer inoperative. An offer once accepted cannot be revoked or withdrawn. Next we are going to discuss different types of agent or classification of agent. So one is mercantile or commercial agent. So under mercantile or commercial agent, the one is that is called as broker. A broker is a mercantile agent who is engaged to buy or sell property or to make bargain and contract between engager and a third party for commission. So broker means a person or who is a mercantile agent, and that person is appointed to buy any type of a product or property, or buy and sell the property or the product, and there is a bargain and there is a relationship made between engager with the third party for certain amount of a commission, in that case that mercantile agent is known as broker. Second one is factor. A factor is also a mercantile agent who is interested with the possession of the goods with an authority to sell the same. So factor is coming under mercantile agent, and he is appointed or he has having the authority for possession of the goods and that possession goods to sell to another for certain amount of a commission received by the person who is known as the factor. The third one is commission agent. A commission agent is an agent who is employed to buy or sell goods or transact business. So during genuine trade transaction, buying or selling of a goods or anything else, when a person is appointed for that activities, then in return of certain amount of commission, then that person is called as commission agent. Then next one is del creditor agent. A del creditor agent is one who, in consideration of extra remuneration, that is called as a del creditor commission, guarantees the performance of the contract by the other party. So del creditor agent is appointed for extra amount of a commission for performance of a certain additional work beyond his authority, and when that person is conducting that service beyond his authority in return of for additional commission, then that person is known as a del creditor agent. Next one is auctioneer. An auctioneer is an agent appointed to sell goods by auction. So when there is an auction take place, in that case one person is appointed who is known as auctioneer, and he is appointed as an agent to sell the goods for certain amount of commission. Next is banker. Though the relationship between banker and customer is originally that of a debtor and creditor, he acts as an agent when he buys or sells security on his behalf. So in case of a banker, the relationship between banker and a customer is same the relationship between debtor and a creditor. So when any type of a buying or selling of a shares or any securities is made, then the banker is also known as one type of a agent. Next is indentor. An indentor is commission agent who for commission procures a sale or purchase on behalf of his principal with a merchant in a foreign country. So this type of a trade transaction when made between principal and agent, or when a principal appoint a person as agent and agent provides the goods or sells the goods to a foreign country in return for certain amount of commission, then that agent is known as indentor. Next, second category, that is non-commercial agent or non-mercantile agent, that is wife as the agent or any sub-agent. Agent's agent is known as sub-agent. Another classification of agent, that is general agent, and the second one is special agent. So general agent is one, that means when one agent appointed on behalf of several principal for conducting his service, that is general agent, and a special agent is one who is appointed on behalf of a particular principal or for a special type of activity, that is called as a special agent. Then we are going to discuss the rights of an agent. What are the different rights of an agent? First one is right to remuneration, which is mentioned under section 219 and 220. As agent is appointed on behalf of the principal, so agent is entitled for his agreed commission or remuneration, and if there is any such agreement or if there is no such agreement, to a reasonable remuneration on the basis of a service provided by the agent to the principal, but agent must have the right to get certain amount of commission or certain amount of a remuneration. Then second one is right of a retainer, that is mentioned under section 217 of the Indian Contract Act. This is known as agent's right of retainer, that means it can only be claimed on money received by him in the business of the agency. He cannot therefore retain sum received by him in one business for his commission or remuneration in other business on behalf of the same principal. So the right of retainer means an agent has the right to retain the goods or the property or the amount if the principal is not liable to make payment on behalf of that service provided by the agent, or if the principal is not making payment of commission or remuneration. In that case, every agent has the right to retain the property or the goods unless and until the payment is made by the principal. Then right of lien, that is mentioned under section 221. In the absence of any contract to the contrary, an agent is entitled to retain goods, papers or property, whether movable or immovable, of the principal received by him until the amount due to himself for commission, disbursement or service. So right of a lien is one type of a right of an agent, that means agent has to retain everything, property or money or anything else, whether movable or immovable, unless and until the amount of commission or remuneration is paid by the principal. Then right of stoppage in transit, this right is available to the agent in the following two cases. That means where he has purchased goods with his own goods or by incurring personal liability, like an unpaid seller, he enjoys the right of stopping the goods in transit if in the meantime the principal is become insolvent. So, when the principal is become insolvent and agent has purchased the goods with his own goods, then in that case the agent must retain the goods unless and until that claim is not settled. The second one is where he holds himself liable for the price of a goods sold. For example, del creditor agent, he may exercise the unpaid seller for a right of stopping the goods in transit in case buyer insolvency. So, that is the another case, if agent supply the goods and during the supply of goods or before reaching the goods to the buyer destination, buyer becomes insolvent, then agent has the right to retain the goods in stoppage in transit. The next one is the right of indemnification, which is mentioned under section 222 and 224. The principal is bound to indemnify an agent against the consequences of lawful acts done by the agent in exercise of authority conferred of him. That means when agent provides all type of a service with a reasonable skill and diligence, or any type of wrongful acts made by the principal, in that case the agent has the right to indemnify all type of claims or the expenses made by the agent towards the principal. So, that is one example that is made. B at Singapore under instruction of A of Calcutta contract with C to deliver certain goods. A does not send the goods to B and C sues B for a breach of contract, and B informs A of the suit and A authorizes him to defend the suit. B defends the suit and A is compelled to pay damages and cost and incur all type of expenses, and during that time A is liable to B for all type of damages, cost and expenses. According to section 224, an agent cannot claim indemnification for criminal act even though the principal has agreed to do so. Then the next right is right to compensation for injury caused by principal's neglect. That means if negligence of a principal is made and any type of a wrongful act or injury is made by the agent, in that case the agent has the right to claim all type of expenses relating to the injury, as that expenses or that activities is made by the principal negligence. Due to the negligence of the principal, agent suffered a certain amount of loss. So, in that case agent has the right to claim that amount of expenses from the principal. That is mentioned under section 225. The principal must make compensation to his agent in respect of a injury caused to such agent by the principal negligence or want of a skill. Due to want of skill, the principal must liable to make all type of a compensation. Then we are going to discuss the duties of the agent to conduct the business of a agency according to the principal direction. So, every agent, as they are appointed on behalf of the principal, duties of an agent must do all type of activities according to the principal instruction. The agent should conduct the business with reasonable skill and diligence that is generally possessed by the person engaged in a similar business, except where principal knows that agent is wanting with the skill. That means the every agent is liable to conduct the business according to the principal and as per the skill and diligence made by the agent. So, agent is liable to provide all type of service with utmost care and reasonable skill and diligence. The third one is to render proper accounts. Rendering accounts does not mean showing the accounts supported by the voucher. That means every agent is liable to make or provide all type of expenses, income, whatever he has made during the course of agency to the principal. Whenever principal wants that, the agent must have to provide that. So, rendering of accounts, that does not signify that rendering of vouchers, but the agent must have to provide all type of financial information. In case of a difficulty to communicate with the principal, so whenever agent suffers any type of a problem, so in that case the agent's duty is to provide that difficult situation or communicate that to the principal. Every agent's duty is not to make any secret profit. Whenever any amount of profit is made by the agent, so agent must have to provide that to the principal. Not to deal his own account. Agent account is not deal with business account. Both account is separate. Business account is meant for business or for principal, and a agent personal account is meant for agent personally. Agent is not entitled to remuneration for business misconducted. If one agent misconducts any type of activities or doing any type of activity illegally, in that case principal is not liable to make payment of commission, or agent is not liable to take that amount of a commission. Next, duty to protect and preserve the interest of the principal in case of his death or insolvency. So whenever principal dies or principal becomes insolvent, in that case agent is liable to protect and preserve all the property of the principal. So thank you, have a good day to all.